All rise. The Court of Appeals Division 1 is now in session.
Thanks. You may be seated. We are here on our case number 1CASA170184, Pace versus the Honorable Mark Brain. Counsel, as you know, each side's allotted 20 minutes for your argument. The petitioner may use any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you both if you, when you approach the podium, give us your name and the name of your client. We've read the briefs and we've studied the record, including the materials that have lately been filed and the motions directed at those. We've also discussed the case in conference together. So with that, you may proceed.
May it please the Court, Catherine Crecci for Petitioner Yolaran Pace. This is a case about the state and the trial court's continued disregard for this court's decision in Ryder v. Garcia that outlined that the state can refile a case subject to due process limits and that the ability to refile a case has limits. The trial court abused its discretion in this case because it didn't look at the three factors this court outlined in Ryder v. Garcia. This court outlined, or at least applied and looked at in Ryder, whether or not the charges were time barred, whether or not the state had a reasonable inference that the defendant may become competent to stand trial, and whether or not the state had ever refiled those same charges after a dismissal based on incompetency.
Well, and we need to turn to the issue of mootness soon, but as long as you've cited those factors, on these facts, the release decision by the hospital is governed by a statute. And the statute requires the medical director to make certain findings about the risks posed either by or to the patient and the patient's overall mental health. Why aren't those at least a reasonable proxy for regaining competence in a due process analysis?
Well, two things. The trial court in this case did not have information that the state was aware that Mr. Pace was going to be released from the hospital. That was presented for the first time on special action. But it's a different standard what a medical doctor makes, or the doctors, the psychiatrists make at a hospital at Desert Vista, of whether or not someone's a danger to self, danger to other, or persistently and gravely disabled. That's a much different standard than whether or not someone's incompetent to stand trial. Someone could still be a danger to self and need to have court-ordered treatment and still be competent, or they could be not competent.
But if the person is not a danger to self, not a danger to others, and not gravely mentally disabled, can't one draw an inference that the person is at least likely competent? Not conclusively, but there is a good faith inference there that the person might actually be competent, especially if the person is released after a week or two.
Well, that's assuming that the reason for the release is because they're no longer a danger to themselves, danger to the other, or persistently and acutely disabled.
Are you suggesting that's not the case here?
I don't think we have any evidence as to why exactly they released him.
But he had to, in the judgment of the medical director, have satisfied those three criteria to be released. We don't have a lot of detail. I grant you that, but he had to have been not acutely disabled, and if he's not acutely disabled, isn't the likelihood that he's competent?
Well, they can also release someone if they believe that they could be subject to outpatient treatment, so that they don't need inpatient treatment, and so he could use outpatient treatment, that he still needs outpatient treatment to address any of those factors that they still believe exist.
There are changed circumstances, at a minimum, that the mental health picture has improved.
I don't believe that just because someone's released from Desert Vista, know that their mental health has improved. Just because Desert Vista is going to release them. There's cases where Desert Vista will release people because they no longer have space to release them.
I think you can certainly argue on a case-by-case basis that somebody remains incompetent even though Desert Vista made that decision. But to argue that the state is essentially depriving someone of due process in bad faith is a harder argument because there is new evidence that the state has relating to competence, isn't it?
I think it's two different standards. Whether or not someone's being released from Desert Vista, I don't think that gives them now this reasonable inference that there may be a change in competency.
It doesn't say much for Desert Vista. I mean, if we have to assume that Desert Vista is acting pursuant to the governing statutes, don't we?
Yes.
And we can't impose upon law enforcement the burden of assuming that Desert Vista is not acting in accordance with the governing statutes.
Correct.
Okay. Perhaps we should turn to mootness.
That's fine. The state argues in their latest kind of addition to the record that this issue is now moot because Mr. Pace has now been found competent. The question before this court is not whether or not Mr. Pace is currently competent or what. It's more of whether or not the trial court abused its discretion and how it applied the information it had at the time that the trial court addressed the motion to dismiss.
Do we have the ability, though, to afford any relief in this case? He's been arrested. He's been found competent. What relief can we grant apart from an essentially advisory opinion?
The relief you could grant is that you could find that the trial court abused its discretion. You could review the record that the trial court had at the time that it addressed the motion to dismiss.
But does that bar a subsequent filing suggesting that there are changed circumstances? The state believes the defendant is competent, and a hearing and a finding that he is competent to stand trial?
For them to refile charges a third time if the case is dismissed?
Well, let's just say this is the first time. Let's say there was some problem with the first finding. By sending it back, would that preclude a subsequent proceeding where the state believes that that the defendant is competent, there's a hearing, and the court finds that he's competent? The court can't even proceed with a hearing to determine if the defendant's competent?
I think the court could proceed with a hearing, but the information that the court had prior to making its ruling in this case was very limited. The state hadn't responded, and I don't believe that if we remanded it back to the trial court, the state will get an opportunity to respond to the motion, to get additional time and information to present that to the court. I think what would have to happen is that if it was remanded and we found that the trial court abused its discretion, didn't apply the factors correctly, that this court could review on the record what the trial court had before it and apply the standard de novo and say, looking at those three factors, find that this case should have been dismissed. And then if the state wants to subsequently refile the same charges, they could do that, in which time an evidentiary hearing could occur if this same issue was challenged on the third refiling.
What in your view, moving on, unless there's more questions on mootness, what in your view is the standard under Ryder for a refiling in a case like this where limitations has not run and this is the first refile, if you will?
I think that I think we need to look at more than just the statute of limitations. In this case, Mr. Pace was in custody for approximately 6 months or over 6 months, which is the time that counts 2 through 6 that were pending against him. That's the maximum amount of punishment he could have been imposed for any of those counts. He was already in custody for that long. So I think we look at time barred not only as a statute of limitation matter, but as how much time they were in custody or were subject to competency evaluations previously or restoration. I think we also look...
But let me address that. This is important because we recently had a case in this court with an individual who went in and out of the Rule 11 process and wound up serving a great deal more time than he otherwise would have been required to serve. Are we doing a disservice to your client right now by conducting this hearing when he already has enough time served to end this matter?
Are there other charges that are pending?
The state did subsequently refile the second case that was against him, so that is also
So he
pending.
could potentially face more than he has credit for today.
In the second case, I believe so.
There's an assault charge in that, isn't there?
And there's a criminal trespass in the other charge. This case involves an assault and misdemeanor related counts. The other one's a criminal trespass. So I think it depends on which one they go to trial first, which one of the felonies he could
Just
potentially
want to make
face
sure that we
additional
are
time.
not party to a procedure that, in the interests of protecting his due process rights, deprives him of his liberty longer than necessary.
He's also currently out of custody.
Okay.
Oh, is he in,
He's not in
Is he in
Desert
placement?
Vista. Yes.
is he in placement? Okay. So that was my question under Ryder. So you've mentioned the length of time in detention for whatever reason. What other factors in Ryder would apply to bar refiling here?
The other one is whether or not the state has a reasonable inference to believe that that the defendant, or in this case Mr. Pace, may be or may become competent to stand trial. There's this intention to discharge that's filed by the state as their Exhibit A, I believe, in the state's response. That was not presented to the trial court. That just merely states that this person's going to be discharged. We don't know the reasons why, and there's no additional information provided with that. However, the statutes recently changed, and the state and the court are now being provided information as to the reason for discharge. So if the state wants to continue to do that, that's something that the state would be able to have access to, the reason for discharge.
So I'm sorry for interrupting, but the statute then you're saying applies to a Desert Vista discharge? Is that what you mean?
Yes. Yes, recently, as of August 9th, the statute changed 36,531, subsection E, that in addition to just giving the notice, the medical directors also has to provide the patient's records, including medical and treatment records, to the court and the prosecuting agency, as well as the addition to just the notice of release. And so I think the state could have had something here. I don't think they have any change except for this notice of potential discharge from the hospital. And there's a number of reasons that someone could be discharged from Desert Vista. And so I don't think that alone is sufficient. Furthermore, the trial court had no notice that the state even had that information when the court denied this motion to dismiss. So the court didn't even analyze that factor. Finally, it's whether or not the state has ever refiled and then dismissed based on incompetency previously. There's 134504 says that if it's previously there's been a not competent, not restorable finding, that there can be a hearing on specifically on misdemeanor charges. So that one's treated a little bit differently than the felony charges. In this case, the court just essentially talked about how it had previously looked at a similar motion to dismiss, and it denied the motion to dismiss, and the attorney had attempted to file a special action, and that jurisdiction was denied in that case. So the court was essentially inclined to also deny the dismissal in this case. And then in the court's minute entry, it looked at whether or not the defense attorney had requested an evidentiary hearing, which is not, I don't think, necessarily a requirement under Ryder for the defense attorney to request an evidentiary hearing. Rule 11.6a, subsection 4, indicates on the court's own motion it can hold an evidentiary hearing at any time. So if the court felt like there's additional information that it needed, it could have set an evidentiary hearing. But at that time, the court was willing to rule on the motion without having a state's response. And so I intend to reserve it. I wanted to reserve 5 minutes for rebuttal to the state's response. So just in closing, initially, this court took a big step towards due process in Ryder, but I don't believe the trial court and the state are applying this court's analysis, the factors that this court looked at in Ryder. The state admits in their motion that they're refiling cases repeatedly, that when people are found not competent, not restorable, and yet they're not presenting this information as to why they have a reasonable inference that there may be a change in competency.
But today, if I understand you correctly, the new statute would mitigate some of that perceived problem.
I believe that applies if the Superior Court retains jurisdiction over the case, which is a discretionary standard that they have under 1345-17, which also recently changed as of August 9th, and that allows the trial court that it may retain jurisdiction. I'm seeing in the practice that the trial court's not retaining jurisdiction of the criminal case while someone is subject to this civil commitment.
Why would the court want to do that?
In hopes, I don't know why the court would do that, hopefully to avoid the refiling, that it would just come back on the same case. But I think then we potentially run into issues of cell issues where they're potentially being forcefully medicated in order to regain competency. So I don't know whether or not that statute will hold up. I think it's a different question for a different case. And so I'm just asking that this court find that the trial court abused its discretion in the way that what factors the trial court looked at in this case based on the information the trial court had at the time of denying the motion to dismiss.
Thank you.
Good afternoon. I'm Julie Wierzinski, and I'm representing the state of Arizona in this matter. To clarify, there is a Class 4 felony in this case, so the defendant is nowhere near serving his complete time, because that's 2.5 years for the presumptive. Additionally, while the state agrees that we do refile some of the cases, there are some cases that are never even considered to be refiled, and those would be cases that are not sent to the state or Desert Vista Behavioral Health because of maybe it's a cognitive issue. That is something that we're not going to be able to fix. We're not going to be able to medicate. So there's a whole series of cases that are not considered. In this case, it was different, and that was because of the specifics of this case. However, Maricopa County has the right to refile cases on a defendant after the case has been dismissed because the defendant is incompetent and not restorable, and we did not violate the defendant's due process rights. As stated, the only information that the state is available to have is a notification that the defendant is going to be released from the hospital wherever he is set. Desert Vista.
What do you mean by that?
Well, we're not entitled to review the records.
You mean from the hospital?
From the hospital.
From the facility.
The only thing we
Under
get.
the new statute?
I have not seen the new statute come into effect, so I can't speak about that. But as of this case, the only thing we are entitled to is notice that the defendant is going to be released. And they notify us specifically that they are going to discharge the defendant. And it can say, because further treatment isn't warranted, because they're being discharged from the facility, the civil commitment order is over. There's numerous different checks that they can make on those, and they provide that to us. That is the same information that the state had when we refiled the Ryder case.
Are there some of them, I'm just looking at that form, are there some of those that would not justify refiling?
Yes.
Which ones would not justify the expiration of the period for treatment ordered by the court? Is that?
That could be one of them, because then we know that he's not going to be ordered to take medication anymore. More than likely, what checks into whether or not we're going to refile a case is what the doctors have told us at the time that the case is dismissed. In some cases, the cases are dismissed because the defendant refuses to take medication. That's like this case. He was refusing medication. If we send him to a civil commitment hearing, they could order him to take medication. Now, for Desert Vista, it's a little different theory. What they are, they're a medical necessity building. So they have to keep patients for medical necessity. Once they are medically cleared, they have to do something else with them. They are not a long-term facility. Unfortunately, the only long-term facility is Ash, and almost no defendants go there. So you can be under a court order. You can be found to be danger to self, danger to others, persistently and acutely disabled, or gravely disabled, and be released from that facility. What you cannot be is actively dangerous. You can't be a danger to yourself or others. You have to be completely stabilized before they can release you to the community. And that is the change of circumstances that the state sees. The defendant had to have improved to the point that he was no longer a danger to himself or others to be released to that, from that community or from that facility. The state has no power to evaluate a defendant outside of pressing charges against them. So we can't just pull somebody in off the street, have him evaluated, and determine whether or not he's competent to stand trial. And as defense counsel was stating, Desert Vista doesn't deal with whether or not they're competent to stand trial. So even review of the medical records isn't going to tell us whether or not he's able to deal with his attorney.
So you don't think that the release itself creates the inference of improved likelihood of competence?
I think what the release does is perhaps remove the impediments to restoration. In some cases, it restores somebody to competency. In this case, he was ordered to take medication. He's taking it, and the doctors that evaluated him after the motion to dismiss was denied said he was competent to stand trial. So it can. In several cases there is no Rule 11 requested the second time. And in some cases, it doesn't work, even if they're medicated. This defendant could have come back, been ordered to take medication, and he still might not have been competent to stand trial.
And what if that happened and he were then released and the state arrested him again?
Well, funny you ask that, because that has happened. On very few cases, and three of them I think were examples in defense counsel's petition, we have rearrested a third time.
And does that raise Ryder implications?
It's getting closer, I would say. In those cases, as you can see, the restoration that takes place in Maricopa County does not take nearly as long as the statute allows. As soon as the doctors realize that they cannot restore the defendant in the current condition, they will file a report and say that we can't restore him. In this case, he was in restoration for about 3 months when they said, he's not taking medication. I recommend either he have a cell hearing or a civil commitment because we cannot deal with him in this manner. In the cases in this that have been explained, in 2 of them, after the second time, we were unable to do anything. They've been dismissed, and we did not refile on them. Even though in one of the cases he did come back on a misdemeanor and was found incompetent restorable, we still did not try to rearrest him a 4th time. In one of the cases, the 3rd time he was found competent to stand trial. And depending on the seriousness of the case drives how far the state is willing to go to protect the community. Because our option is rearrest him or have him released to the street. And while he might be under outpatient care, it is not in a locked facility. It is not in a facility there. Potentially there's nobody else there. He could be living on his own, and it's a voluntary system. So we're very cognizant of the public safety aspect. Because the civil commitments don't deal with the competency issues.
I'm sorry to
Okay.
engage in what might seem like a law school trick, but what about the 4th time?
You know, and we weigh that very heavily. And on the cases that we've done 3 times, we have decided, because we thought it was close, we're not going to do it a 4th time.
Okay, but you would agree that
There is
the
an
4th
end.
time, I mean, at some point, Ryder really does compel a result.
Yes, and because Jackson versus Indiana says you cannot just keep refiling and refiling and refiling.
Okay. I'm sorry.
I would think that it would get closer and closer when you're getting close to the time spent in restoration that you would be allowed fully. I know in Silva, the time overlapped the 21 months if you took it all at one time. That case was decided after the Noel case, and it never occurred to anybody that you had to add up the time. We all thought at that point that it was a new time each time you went into restoration. So when you did add that one up, in hindsight, it did appear to go beyond. But that could have been dealt with before appeal had Noel been heard before that. So another argument in the case was that the state was taking advantage of the 21-month period of time that the defendant was found to be incompetent. So you can't, inferring that you cannot refile until that 21-month period is up. And the state would contend that is inaccurate because, of course, the 21-month is the time frame where the defendant was similarly situated. In this case, of course, he was ordered to take medication. He was taking it. It's not a get-out-of-jail-free card for that whole 21 months. It depends. It's just that's based on what the treatment doctor is saying at that point. In this case, the defendant was found incompetent and restorable. He was placed into restoration. 3 months had passed. The state did ask for a hearing because we wanted to review the records. After the records had been reviewed, there was a stipulation that he was incompetent and not restorable. We did nothing. We filed the civil commitment pursuant to the court order, and then we did nothing until we were notified that the defendant was being released. And that is what triggered the stabilization and release of the defendant, was what triggered the re-indictment. The state does not believe that Ryder supports the defendant's case in this instance, and that is for a couple of reasons. As I stated earlier, we had the same exact information we had at the time that Ryder was re-indicted. In that case, I got a phone call from the Attorney General's office saying, we're releasing him. We wanted to know if you planned on rearresting him. I said, yes, we want to do that. So it was 2 months later that defense counsel filed the writ of habeas corpus, and her motion to dismiss was based on lack of personal jurisdiction. And the lack of personal jurisdiction, in her view, was because the defendant was under a court order for treatment. Therefore, we could not reinstitute prosecution. The evidentiary hearing was per her request. The records were obtained by defense counsel, and they were ordered to be provided to the state a month after the writ was filed. So we had no information regarding what had happened with the defendant about 3 months into the prosecution when defense counsel was ordered to provide it to us. The statute of limitations, of course, has not passed because we have a Class 4 felony. There is an inference, if the defendant is being released, that he has stabilized to the point that restoration might be possible, and the fact that we had not refiled this case previously. As I stated, release from the hospital can mean a variety of things. It can mean that they never needed services before. That has happened because we have psychology is not an exact science. It is an informed view of how the defendant acted when you saw him and your review of the records. It is possible for defendants to pretend to be incompetent when they are not. Often, when they are taken to Desert Vista, an individual who doesn't remember his name while he's in jail is suddenly fine, faced with the ability to get out of the hospital. That could be a possibility. We don't know. It could be that the defendant is now willing to take medication because he can get out of the hospital if he says he's willing to take medication. That gives us some information, too. It gives us information that the defendant can use his judgment to take steps that better himself and that are in his best interest when faced with if you take medication, you can get out of this hospital sooner. It can also be placed under a court order treatment and be forced to take medication. And in those cases, like this one, once the defendant takes medication, it could be a drastic change in his presentation, as was found in this when he was found to be competent by the doctors when they evaluated him. In any case, everything the state does is prefaced by the motion to discharge from the hospital. Sometimes it's quick. In this case, I think the normal is 3 weeks. Sometimes it's quick. Sometimes I'm waiting 10 years on some cases where the defendant is a long-term patient at ASH because he is still not stabilized. So, again, as soon as they notify me that there's been some change, then we'll review it, make sure that we think that the case is good and whether it requires a refiling, and then we'll make the decision. I believe that defense counsel, when they review Ryder, because I thought I won, is taking it the wrong way. I think Ryder says that we do have the ability to rearrest and reindict someone after they're found incompetent, not restorable, as long as it's not in violation of their due process rights. I know that being in jail is not pleasant, but the defendant had an IA. He had the ability to have a motion to review his release conditions. He's had all of these things, and his due process rights have not been violated in this matter. He has been in jail less time than he would for a normal presumptive sentence in this case. And the case clearly says, Ryder says, we hold, subject to due process limitations, that the state can refile the dismissed charges and renew its effort to restore the defendant to competency. If the state had to prove that the defendant was already competent, there would be no reason to restore a defendant to competency. And that is what it says. In this case, we believe that the circumstances warranted a refiling of the matter. We believe that it's a public safety issue. And that is why we refiled in this matter. Are there any other questions?
We're good.
Okay, thank you.
Thank you.
The state argues in this case that their issue was with Mr. Pace was that he wasn't taking medication, he wasn't complying with medication. Yet the state had stipulated to him going into restoration of competency with Correctional Health Services, where the state is aware that there is no psychiatrist on staff to address the medication element as far as regards to competency. And yet after that, the state also stipulated that he was not competent, not restorable, and effectively is using Desert Vista as a workaround in order to get, in their case, in hopes that he gets compliant with medication. I think what the state's arguing before this court a lot of information that the trial court did not have when the court analyzed this issue. And this information, the fact that the state even had this notice of discharge from facility, was not something that the trial court had. And I don't believe that as a state...
Isn't it something the trial court could have inferred? How else was he released?
The information we just have is that he was rearrested at Desert Vista. We don't necessarily know that he's going to be released.
Police didn't go into Desert Vista and take him out of treatment. I mean, that would be a very different sort of case, right? The police knew that he was being released, and so couldn't one infer that there was a release order?
The only information I think that the trial court had would be an information presented at the initial appearance. Let me see if it has it. I don't know if it was presented to this court, that essentially the location of his arrest was at Desert Vista. He was arrested at Desert Vista. So, I mean, people are arrested at the hospitals all the time. I don't think that just because he was arrested at the hospital, the court could presume that he was going to be released from the hospital. Any other questions?
Thank you.
Thank you.
Thank you to both of you for your briefing and for your argument. We'll take the matter under advisement and we'll issue a decision in due course. Now we will adjourn.